All right, hi, welcome back. Attorney Steve Vondran here. Welcome to another exciting video. Thank you for joining us. All right, so we're talking about copyright small claims. I've talked about this in many other blogs, videos, and I just tell you because if you're a creator, you create things, photos, digital video, drone video, underwater video, landscape art, any of this stuff, any of these creative works of authorship that are fixed in a tangible form of expression or medium of expression is subject to being copyrighted. So now with the new small claims court, you have to be careful really out there, everybody. And that's because there are claims up to $30,000 and these can get pretty hairy. And I've talked about this in another video. I'll link below some of my other small claims videos for you in case you're in small claims and you're wanting to check it out. You don't need an attorney in small claims court. Attorneys are optional. As in regular small claims court, usually they don't even allow attorneys. So this is kind of a bump up for copyright lawyers. Anyway, so I want to talk to you about a unique use of the Copyright Claims Board, which is out in Washington, D.C. It's not a real court. It's a claims board. It's made up of board members that basically hear your claims. It's all electronic. It's digital. You don't have to show up and get all nervous like you do in other small claims or court cases. So it makes it actually really nice if you're a creator, artist, illustrator, anything like that. And I have a unique case here for you. Now, I love Etsy. This case deals with an Etsy seller and somebody that owns a copyright to a very unique item, which I'm going to show you, okay? But this is on Etsy, and what happens, the basics of a notification or a takedown. If you find somebody using your digital artwork or any of your copyrighted content, anything, you can send a takedown letter to Etsy. They will take it down. And if the other party does not file what we call a counter notification, then it will just stay down. However, if the other party says, I'm not infringing anything, or this is a mistake or misidentification, what is this? You can file what's called a counter notification. And normally most companies, because they don't want to be sued, like Etsy doesn't want to be sued, they want safe harbors. Google doesn't want to be sued. YouTube doesn't want to be sued. TikTok doesn't want to be sued. So they they get special safe harbors. But in this case, what happened is the Etsy seller has a unique copyright, and you can see here her name. This is all public record, so I have no issues in putting it down here. But here's what a claim looks like, okay? And I just want you to focus on this. This claim is being brought for misrepresentation under 17 U.S.C. That's United States Code 512F as in Frankfurter, 17 U.S.C. 512F. Now, this is a misrepresentation claim, and it's a very unique use of the copyright courts, and they do hear these types of claims. Here we see proceeding as a smaller claim under the $5,000, up to the $5,000 monetary limit. So this claim is being brought saying, look, I sent the takedown notice, a DMCA, that stands for Digital Millennium Copyright Act. I sent the takedown notice to Etsy as the service provider here. And of course, like I said, as long as they take it down, you can't sue them, and they usually will take it down. Some people say some of the bigger companies may not if they're under certain circumstances. I'll save that for another video. Date that the takedown notice was sent. Here it is. Who sent the counter notice? So in this case, the respondent in this case, sent a counter notification. Basically, in a counter notification, I'll show you in a second, you're basically asserting that you had a good faith belief that there was a mistake or a misidentification in the takedown notice. And then when you do that, then Etsy or other providers online service providers as they're called, will put the image or the content back up. Okay, unless you go file a lawsuit within 10 days, okay? So that's pretty much what happens. That's what happened here. And what this plaintiff or claimant is claiming is, as I just noted, The legal statement that the respondent legally signed stating, "I swear under the penalty of perjury that I have a good faith belief that the material was removed or disabled by mistake or because of misidentification of the material." That's a certification you make when you file a counter notification. Everybody makes that certification, DMCA law, okay? It says this is a complete misrepresentation. That's why they're suing for up to $5,000. As the listing was clearly infringing on my copyright registered design. So here we have a case not dealing with a photo or an image, but yes, you can copyright a design. And I'll show it to you in 1 second. It's really cool. I am the only person with the copyright on this design and the only person authorized to sell any copies of it in any format without a licensing agreement. There is no such licensing agreement between myself and the respondent, and I would not consent to another person manufacturing my original design. So what happened is, due to that, the damages suffered. You have to allege what your damages are. The listing was reactivated on Etsy due to the false counter notification. They're going to allege making profits off them will cause confusion among the public. Okay, so let's take a look at it here real quick. So here is the plaintiff or the claimant's work. Very cool. Look at this. These what elf wings or moth wings, butterfly wings. So those are very cool, right? So let's take a look at this. So here is the let's take a look at this copyright. This is the copyright. Visual arts up here, registered in December 2015. It's Titania Fairy Wings. How cool is that? Date of first publication 2007. Here's the author. That's the person that's suing. Fancy fair wings and things, 2D artwork. That's pretty cool, right? So anyway, so just alleging that it was on the Etsy person's website, and then they sent, let's see if this is a counter notice. I swear under penalty of perjury I have a good faith belief that the material was removed or disabled by mistake or because of breach or misidentification of the materials. So this is what can happen in a case. When you file a counter notification, you're also, as you see here, consenting to the jurisdiction where you are located. So if you're in California, Southern District in San Diego, or Central District, Los Angeles, Northern District, Oakland, San Jose, Bay Area, then you're consenting to be sued in that area. So it is kind of interesting that the case is filed here in Washington, D.C., so that's pretty interesting to me how there may be some issues here if this actually gets litigated. Plus the question of whether the 512F as in Frankfurter claim will work. So we will keep you posted on that. And if you need help or representation in a copyright matter, you know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I got to run. Take care. Have a great day now. Thanks for watching. This is general legal information only and not legal advice.